read a legal disclaimer. This presentation is not intended as legal advice. Every situation is unique. So please consult with your family's legal counsel to develop a plan that best meets your needs. If you have any questions or reach out to me or any other individual that does special needs planning after the presentation. This lovely lady that is in the PowerPoint presentation is our 25-year-old daughter, Abigail. So not only do I do this for a living, I'm very passionate because I live it every day with our beautiful daughter. So we'll jump right into the transition planning. The first couple slides were the ones that we have already gone over in the other presentation. Okay, so transition planning, the key course is you're transitioning from school age to adult. Under IDEA, free appropriate public education, transition planning is required to be discussed beginning at the age of 14. And as you get closer to the exit of school, those discussions should begin to be a much more fluid conversation, more stakeholders at the table, and really zeroing in on what your child wants to do in their lives after high school. Some things that you should be discussing is their readiness for adult community living, vocational skills. Do they have skills of independent living? Is the plan to have some help from DDA, have traditional supports, or living at home with supported decision making, supported living, those type of decisions, self-direction of DDA are things that are really important when your child turns 21. At 18, as we were discussing, they become an adult. There are certain things that you should be looking at when they're approaching 18, be qualifying the individual for SSI, Medicaid, and those type of governmental benefits that could be very important for your child as they become an adult, and we'll explain the reasons why here. What are we planning for? Well, we're planning to meet basic needs, but what else? Enjoyment, both emotionally, personally, a fulfilling life. That's what every parent wants their child to have as an adult, is very wonderful life, something that's very fulfilling. What's the comfort and quality of life? That's also really important when you're planning. Security and safeness, that's very important. Are they going to be part of the community? Are they going to be going out in the community? Are they going to have a job? Are they going to instead do daily activities, have get together with friends, go bowling? Those are the type of things that this planning is very important for, to have a rounded adult life. So think ahead about what makes a good life for your child. Each child's different, each family's different. What does that look like? If your child is able to have some input to it, listen to that child, listen to what they're saying to you that's important to them. Be a sponge, go out, learn about organizations, learn about what DDA benefits are out there. I'm starting to have a parent group where I'm getting involved with other parents who have individuals that are close to my daughter's disabilities. Talk with other families about what they're doing. Are they going traditional? Are they doing a group thing together? A lot of parents nowadays are pulling their resources together and coming up with some creative solutions. Look at your circle of support, your family, your friends, employers. What's out there that you can tap into? Again, being a sponge. And then advocate. Don't be afraid to step up and advocate for your child and what they need. And the last thing on this slide is a letter of intent. A letter of intent is very important. It's really outlining what your child needs, what your child can do, what the child needs help with. what type of benefits does the child have? Or once they do qualify, what does SSI mean? What is it? What are the parameters? So someone who can step into your shoes has a step up in all this knowledge and all this learning that you're undertaking. So when they go to take care of your child as an adult, that they're a step ahead with what they need to learn. Again, a letter of intent, describe your child, tell their story. It really gives a good insight. Also, potential areas to address are housing and residential care, their education, any employment, what's their medical history. I think that's very important, who their doctors are. How did you address a particular problem? Is there a specific behavior that is, that you are working on? Is there a behavior plan? What type of social environment does your child enjoy? Who are her friends? Those type of decisions and those type of things that your child is involved in is really helpful for someone who would be taking care of the child once you're either not available or not here. So planning is a process. Develop goals for yourself and your child. Determine the proper tools, what documents you need, what are the steps to achieve your goals. Then take action, and then revisit the plan periodically to make sure that everything is still working well and that it's going towards your goals and the goals for your child. So I often say that planning is a journey. So you set your goals, you select the tools, you select the right people to implement those goals and objectives. You test it out. If it works, great. Not, you regroup. And then again, you review and you update as necessary. It's just this constant type of journey that we're all on. And that I think that each year the journey just involves just going through this process over and over again. And I think this is a great example I can give you. Like our daughter transitioned from the Maryland School for the Blind in 2020. We started out with a traditional agency providing supported living in our own in her own home, and this was working great for 3 years, and then they made one change to a staff member and it all just went downhill from there because Abigail had issues with adjusting. So we are now self-directed. So for our DBA services. So again, we stepped back, it wasn't working, we had to regroup, we went back and figured out the plan. This slide I think is really important, and I can make this available to you guys as well. Just as a standalone, Brittany, I'll forward that to you. But this really is tells you exactly what you should be thinking and what's ahead in the adult world. So when we're talking about these are supported decision making, parents estate planning. We're going to get into that, envision a good life, and government benefits. They all come together in this pie. And they all are intertwined, and they all are important to look at all of these decisions. We talked about the capacity, the guardianship very briefly tonight. Will, special needs trust, choosing a trustee, beneficiary designations, powers of attorneys. These are all really, really important. And then what's in the community, what's available, what is going to be, where are they going to live? What's their circle of support? And then the government benefits, which can be means tested or cannot be means tested. What does means tested mean? That means that there's a certain level of income that you have to be below for them to qualify for those government benefits. So for instance, SSI, you can't have more than $2,000 to qualify. So that's a means tested government benefit. Let's first look at the legal considerations. Government benefits, state planning, special needs planning, resources and services and supports. So the government benefits, we have Social Security benefits, we also have medical benefits, and we have disability benefits, which also would include services and support. So this is going to be your SSI, your SSDI, just social SSI, SSDI, it could be Medicaid benefits, it's going to be perhaps SNAP, which is food stamps, it could be Section 8 housing. So there's a variety of different governmental benefits that your child may or may not qualify for or need. So what is the requirement for Social Security benefits? It's not as, it's a standard that's different. It's the child has to be unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment that's going to result in death, or it's going to continue for at least 12 months. This is important because it's any substantial gainful activity. So if your child meets this definition, they're going to qualify for Social Security benefits, which will be your SSI and your SSDI. And also when you go to retire, then they will move into another type of benefit, which is commonly known as dependent adult child or DAC payment. So we'll go over that as well. So supplemental security income is really what a lot of the transition youths qualify for. It's currently $967 for an individual in 2025. We still have the resource limit of $2,000 at any given time. What's nice in Maryland is that if your child gets SSI and qualifies for SSI, they are automatically eligible for Maryland Medicaid, which is another name for medical assistance, which is, some states are not, it's not like that. You have to apply for both programs, but in Maryland, automatic, if you're eligible for SSI, you're automatically eligible for Maryland Medicaid. When your child turns 18, your assets do not count towards their eligibility for SSI. So they don't deem your assets. If you apply prior to the age of 18, they will deem your assets for eligibility purposes. What's SSDI? SSDI, Social Security Disability Income. This is a non-means tested benefit. You still have to meet the definition of the Social Security Administration's disabled definition. It's based on work history. It's either based on one's own history, your child's history, if they have any, or your own, meaning the parents' work history. SSDI eligibility also makes you eligible for Medicare after 25 months. There would be a separate application for Maryland Medicaid. It's not an automatic Medicaid if you have SSDI. That only applies to SSI. And there's a special benefit for people disabled prior to the age of 22 to collect under your work record. The adult child, or DAC, is a payment where the disabled adult child receives half of the Social Security monthly benefit of a parent who has retired. So for instance, let's say you're going to be retiring and you have a retirement benefit of $4,000 a month, and your child received SSI, and upon your retirement, that SSI benefit is going to go away, and they're going to start receiving half of your Social Security every month. They would still, under Maryland law, be eligible for Medicaid because they were on SSI, and the only change in this scenario is that you retired and SSI is going to be less than probably your Social Security benefit. And because that's the only change, the law's not going to penalize your child because there's been no other change other than that one change. They're also entitled to Medicare upon the 25th month after you retire. Also, if you pass away and the child is receiving DAC, that 50% then becomes 75%. Now, if your child is on a DAC benefit, that is on the non-means tested side, but they would still need to qualify for Medicaid in order to make themselves available to the Community Pathways Waiver for DDA. Excuse me, so the $2,000 limit would still apply for your child even though they are receiving a DAC payment. Most insurance companies, private insurance companies, have clauses in their policies that allow you to keep a disabled adult child on your policy as long as you have the health insurance. So I really encourage you to look at your own policies to see if your insurance company has that benefit. The Medicaid benefit that we've been discussing is sometimes called medical assistance. A lot of people know it by medical assistance. And it's a comprehensive health insurance. There's no premiums for your child. There's no co-pays. There's no deductibles for most of the Medicaid programs. If you're getting Medicaid because of SSI, there are no premiums or co-pays, maybe for prescriptions. My daughter has a co-pay, it's $1. Fewer limits than private health insurance. They can include personal attendant care. But most importantly, it makes you eligible for the DDA's Community Pathways Waiver. That's really important for those that are cognitively impaired and for those individuals with Down syndrome coming out into the community if you want to avail yourselves to those programs. Medicare, and this would go to if they qualify for a DAC payment, what does Medicare cover? It too is a comprehensive health insurance. It's designed for people over the age of 65 and those that are on SSDI or are receiving a DAC payment upon the 25th month of them receiving those benefits. If you're duly eligible for Medicare and Medicaid, Medicaid pays the Medicare out-of-pocket costs, the premiums, the co-pays, the deductibles. This is not means tested Medicare. And like I said, the DAC recipients receive the Medicare benefits after they've been receiving DAC benefits for 25 months. All right, disability benefits including services and supports. I've talked a little bit about the DDA's Community Pathways Waiver. What does that involve? There's different programs, but it allows for staff to assist with your child. Daily activities, could be job supports, could be residential care, there's respite care involved, there's self-direction and supported living. There are other waiver programs in the state of Maryland. There is the model waiver for children who are medically fragile. It is possible to remain on the model waiver after the age of 21. It usually is not an option because of the cost factor. Gets more expensive after you're an adult. So for instance, if you're on the model waiver, you're having private duty nursing, the private duty nursing becomes very expensive as an adult. Don't ask me why, but it does. So the model waiver would reduce your nursing pretty significantly. So most people come off the waiver at 21. The autism waiver, you cannot be on 2 waivers at one time. So if you are on the Community Pathways Waiver, you cannot be on either the autism waiver or the model waiver at the same time. There's DOORS, that's supported work. There's SNAP and food stamps that are available for eligible individuals. And again, Section 8 housing. They're all means tested. They all have different rules, but they are available to help individuals with disabilities in Maryland. Okay, let's switch over to estate planning and special needs planning. So why do we do estate planning? We plan for, really how we want to pass our assets to our, family members, upon our death. Some people, say I want to plan because I don't want probate. I want to plan because I need to plan for tax reasons. So there's a variety of reasons why we do estate planning, but in general, it's really to take what you've accumulated in your lifetime and direct where you want that hardworking, nest egg that you've built up through the years to go. There's a myth that if you don't have a will, that it all goes to the state. That is incorrect. It takes having absolutely no relatives alive, period, including all the way down up your tree, down the sides of your tree. So if you're all, let's say you're all in a car accident, you all perished, and you don't have any brothers or sisters, there's no nieces, there's no nephews, there's no great nieces, no great nephews, then yes, it will go to the Board of Education for the county that you are domiciled in. If you count the 10 years I was a estates and trust paralegal and just about 20 years in private practice, for 30 years, I've had one case where it went to the Board of Education. So it's extremely rare. What is probate? So probate is a court process that validates a will and also guides the collection of the assets, making sure the personal representative that you name in your will is following your document, your wishes in your will. They also are responsible for payment of any debts and taxes, and also making sure that the proper distribution of the assets to your heirs take place. Not all assets pass through probate. So for probate, what goes through probate is anything in your sole name that does not have a designated beneficiary and does not say payable on death. It is very possible, particularly if you're married, that upon the first spouse to die, there is no probate because everything's held jointly, or there's a designated beneficiary, or there's a payable on death. If you have non-probate assets, then, and you leave those assets to individuals that are within your lineal line, meaning parents, brothers and sisters, children, grandchildren, great-grandchildren, there is zero inheritance tax in the state of Maryland. They do, however, if you leave it to nieces, nephews, aunts, uncles, best friend, guy down the street, then there's a 10% inheritance tax in the state of Maryland. And that is also imposed if there are non-probate assets such as a revocable living trust or a designation of life insurance proceeds or a payable on death of an account. If it's to a non-lineal heir, there would be still a 10% inheritance tax levied on that non-probate and probate assets. The key to the inheritance tax is not whether it goes through probate, it's what the relationship is to the decedent. So if you name your children, your spouse, your grandchildren, your great-grandchildren, your brothers and your sisters, your parents, zero inheritance tax, whether it's a probate asset or a non-probate asset. The other thing that I have highlighted here is, you kind of have to put like your hat on. What am I talking about? Am I talking about probate? Am I talking about non-probate? Probate assets are the only assets that go through a last will and testament. Non-probate assets do not go through the will. And that's really important to think about when you're planning your estate and what are your goals and objectives of that plan. There should be a coordination of probate and non-probate assets to really achieve the desired estate planning outcome. So when you do estate planning with an attorney, you're going to most likely get asked to fill out questionnaires. They're detailed and designed to pull out basically what are your assets, how are they titled, and a rough estimate of the value of them, So the estate planner is looking to plan for not only how you want to transfer your assets at your death, but whether or not, is there a special needs child? Yes, yellow bell goes off. There's different planning for that particular child's inheritance underneath your plan. Are you over the Maryland estate tax exemption rate, which currently is $5 million? Currently, there is in the proposed Maryland budget to take that down to 2 million, which we're all hoping doesn't happen because it doesn't take long to get to, a lower limit in this state. But these are the type of things that are pulled out of these questionnaires that are very important for the estate planner to have, so that they are making sure that they are preparing a plan that is best for your situation. So what's a will and what's a trust? A will is a legal document, just like a trust is, but a will instructs how your probate estate is to be managed and distributed after your death, and names the individuals or any type of trust, for special needs trust that might be created for your special needs child, or a charity that you might want your assets to go to upon your death. A trust is a legal entity, and it is created through a valid trust document, and you would be the settlor. You could be the trustee if it's revocable, and it appoints a trustee to manage the assets of the trust, and then upon certain deaths, it triggers either distribution or further distribution where it's held further in trust. So trust is one tool in our toolbox in making an estate plan. There are many types of trusts. What type of trust and the characteristics of those trusts are important to understand to make sure that you are getting your goals achieved with your estate planning. Special needs planning, this is obviously very important to everyone on this call. There are several types of special needs trusts. There's a first party special needs trust, that's also known as a D4A trust. There's pooled income special needs trust. We have a pooled income trust here in Maryland. It's at First Maryland Disability Trust. They do a really terrific job. There's third party special needs trust. And then there's other type of planning that happens when you do your planning, and that's, do you want to open an ABLE account? Do you want to have your power of attorney agent be able to create an ABLE account for your disabled child? There's Section 8 housing concerns if that's appropriate. There's food stamps concerns if that's appropriate. Not one size fits all whatsoever in the special needs planning and the estate planning arena. It really is very individualized. So special needs trust, very important. Why do we use them? It's a way to set aside and manage assets of your disabled child, or any assets that may come to your disabled child upon your passing or during your lifetime, or their lifetime from other family members, and make them sheltered legally for eligibility for means tested benefits. It's really important to use a special needs trust with your planning. And I'll explain why when we get into the different types of special needs trust. The different types of special needs trust, it's really for use of assets for quality of life. They don't supplant government benefits, they supplement the government benefits. And that's really important to know. So whose assets are in the trust? That's going to dictate what type of trust it is. Any assets that are in the name of the beneficiary or the beneficiary receives, it is a first party special needs trust. So for example, let's say that your child is turning 21 years of age and you have an UTMA account, a Uniform to Transfers Minors Act, that was created during your child's lifetime up to the age of 21. In Maryland, if you have an UTMA account, it is a custodian type account. Those benefits at age 21 become the child's, the adults, the young child, your child becomes the owner of those benefits. If he or she has qualified for means tested benefits, that if those assets are over $2,000, it becomes a problem because your child would not continue their eligibility of those government means tested benefits. However, there's a fix. You create a first party special needs trust and you transfer the UTMA account into that trust. And we'll get into how that goes, what's the protocol in making that trust and getting that trust approved and getting the authorization to transfer the UTMA account into the first party special needs trust. The key here, though, is first party trust equals the assets of the disabled person. That's key. So when you're putting your hat on, first party, think, whose money is it? Is it my son or my daughter's, or is it an inheritance coming to my son and my daughter where they've been named individually, not to their own special needs trust, but just individually? That means first party. Third party is everybody else's money, right? So it's going to be your money. It's going to be grandparents' money. It's going to be aunts and uncles. It's going to be friends. That's everybody else's money other than the disabled beneficiary. Those two should not come together. And there's very specific reasons why. Examples of a third-party special needs trust, okay? Parents include a trust in their estate planning documents. Some make them testamentary, which means under the will. Some people will plan and use standalones. I will tell you in my practice, I use standalone special needs trust because you never know who might want to leave the special needs child money in their will. And it's a way that they can name the standalone trust. Versus if you have it underneath your own will, that will does not come alive, so to speak, until you die. And if someone, let's say a grandparent wants to leave money to your special needs child, you're still very much alive, and that special needs trust is not created yet because you haven't died. So if a client comes to me and says, I want to plan special needs plan, I want a special needs trust, and my parents might want to give my child something when they die, we're definitely doing a standalone trust to sit in the center of your plan, but also in the center of your family's plan to make sure that anybody who wants to provide for your special needs child is going into that standalone trust. So that's very important and a very important distinction to make. Okay, whoops. First party trust, we talked about them. It's a standalone irrevocable trust. It's for a single beneficiary, and you cannot add to this trust once you turn 65 years of age. The trust has to be approved by the Maryland Department of Health. So when the trust is drafted, before it's signed, we send that over to the Department of Health along with what they call an attorney checklist. The Department of Health reviews the draft first party special needs trust, and if everything looks okay, they will stamp it as approved. In Maryland, the first party special needs trust is designed and has special provisions in it that are statutorily driven. What does that mean, Victoria? That means that in the law, Maryland law, there are specific provisions that have to be in this first party special needs trust. And If these provisions are not in the trust, then it will be declined from the Department of Health upon the review. Go back and you change it. So it's very important that these provisions are in the actual trust. If we're receiving a inheritance, or if the child's receiving an inheritance or any type of settlement from either a personal injury, a malpractice case, or if they receive money directly, then there has to be a petition filed in the county that your child resides in requesting permission to transfer those assets to the first party special needs trust. So there's two things going on here. As a parent, you have, under Maryland and federal law, the ability to create a first party special needs trust. Easy peasy, right? Create it, send it over, gets blessed, comes back, you're ready to sign. However, under Maryland law, because if your child is incapable of making financial decisions for themselves, and they do not have a valid power of attorney signed, or a guardianship of the property in place, you would have to go to the circuit court and request a single transaction without the necessity of guardianship, particularly if your child does not have any other assets other than perhaps their representative payee account that does not come into play. It takes a couple months to do that. Once you get the order authorizing you to make that deposit, then the first party special needs trust can be signed and it can be funded. And then you guys, the first party special needs trust is set. The Maryland Department of Health requires an annual accounting of every first party special needs trust. So you have to account as the trustee for every penny that comes into the trust and every penny that goes out of the trust. There are specific requirements, such as if you're going to purchase a house in the name of the trust, you have to go and get a court order from the circuit court permitting you to spend more than $100,000 to purchase a piece of property. There's also a requirement that there's special rules about annuities, there's special rules about retirement accounts that are coming into the first party special needs trust. So there's certain things that when you go to create the first party special needs trust, you want to kind of put that in the back of your mind to ask the question, are there any requirements that are special that I need to know as a trustee? The other thing about first party special needs trust is that there's a payback provision. We call it a payback provision. It's a requirement that at the time of your child's death, if there are any assets in the trust, then the first entity to get payment out of that trust before it goes to residual beneficiaries is the state of Maryland or any other state that provides Medicaid benefits to your child during your child's lifetime. So how does that work? Let's say that upon your child's death in the first party special needs trust, there's $500,000. And let's say that during your child's lifetime, the state of Maryland paid on her or his behalf $700,000 worth of Medicaid benefits. So you have $500,000 left in the trust. You have $700,000 that was paid from the state of Maryland. The $500,000 would go back to the state of Maryland. Nobody, though, is responsible for the difference between the $500,000 and the $700,000. They write it off. But let's say that you've created the first party special needs trust. The first party special needs trust says that upon Abigail's death, any assets go to, after the payback, go to Abby's then living descendants. And if Abby doesn't have any then living descendants, it's going to go to her heirs at law, which in our instance, if she has no children, but she won't, then it would go back up the tree and go out to her sisters. So same thing, $500,000 in the trust. At the time that Abby dies, they paid out $300,000 worth of Medicaid benefits. There's $200,000 left in this trust. We paid $300,000 back to the state, and then the $200,000 because we will be gone and she has no, she only has siblings, she doesn't have children, half would go to her one sister and the other would go to her other sister. And that is something that is only for first party special needs trust and only for first party pooled income trust, which we'll discuss first, not next, not third party. Third party is your money, remember, right? What hat do we have on? So third party money does not have a payback provision. Third party money goes pursuant to the trust agreement, and you can leave the money to whoever you want. You can also add to the money, add to the third party trust at any age. And it is not under the jurisdiction of the state. The third party trust, the only trust accounting that's required under Maryland law would be to the disabled individual or the disabled individual's guardian under Maryland law. Another type of special needs trust is the pooled income trust. So a pooled income trust can be either first party or third party. I mentioned First Maryland Disability Trust because that's the pooled income trust here in Maryland. There are national pooled income trusts. FMDT is very good. And if you decide to go and pick another type of pooled income trust somewhere else in the United States, please do your due diligence on them. Make sure that they are strong, that they have, that they have a lot of assets, that they're just financially sound. It's very important. FMDT is very strong, and we're very blessed to have them here in Maryland. A pooled income trust, what is it? It's really set up kind of like a 401k plan. So it's the best analogy I can use to describe what a pooled income trust is. So let's say that my daughter Abigail, her friend Erin, her friend Sally, all have a first or third pooled income trust with FMDT. Let's say that's first party pooled income trust. FMDT has, let's say, 200 other people that have first party special needs trust. So the 200 people plus my daughter and her two friends, let's say my daughter has in her first party pooled income trust $200,000 and her friend Erin has $500,000 and everybody else has their own amount, right? They pool those assets together and invest those assets jointly. And then when they get the income in, then it gets whatever you invest in, like a 401k, you're going to get the income in your journal, right? Expenses of the pooled income are sprinkled or divided by how many people are in the pooled income trust. So you share in the expenses of the pooled income trust. The other thing that pooled income trust is a benefit to is that you can add to a pooled income trust after the age of 65, which cannot happen to a regular first party special needs trust. Now there's a payback provision under the first party pooled income trust. So you would designate after the payback, who you would want to get the remaining portion of your pooled income trust. You can also elect it to stay at FMDT as a charitable donation. That's also an option. A pooled income trust is also attractive when you don't have a trustee that you think would be a good trustee and you're a little concerned about that, the trustee of all the pooled income trusts is FMDT. So you have options. You've got pooled income trust, you've got third-party special needs trust, and you've got first-party special needs trust. The other thing that is in our toolbox is the ABLE account. So an ABLE account in Maryland is ran by, supervised, invested by the folks at the Maryland 529. An ABLE account is also an exempt asset for means tested benefits. You create, an account is created for your disabled child. An ABLE account, you can add or fund, if it's the first addition to this new ABLE account that you're setting up to $19,000 currently per year. You can have up to $100,000 in the ABLE account before it affects your SSI payments. If you go over $100,000, SSI payments will be suspended until you bring the ABLE account down below $100,000. Lifetime in the state of Maryland is $500,000 additions into an ABLE account. An ABLE account is very useful when, let's say your child's going to get an inheritance that's less than $19,000. Instead of creating a first-party special needs trust, you can create an ABLE account and swing that inheritance into the ABLE account without having to do a first-party special needs trust, the petition to fund it, et cetera, that I explained. It's also a really good way if you're not spending all of your SSI payments. Because again, you can't have more than $2,000, right? So if you are either receiving a DAC payment that's pushing you over $2,000 each month, or you accumulate your SSI payments for a couple months and you're going to go over $2,000, you have an ABLE account, you can swing the excess SSI payments into that ABLE account, and that transfer for eligibility purposes for SSI and Medicaid, it's not going to impact the eligibility because it's an exempt transfer. Okay. Practical tips. Plan early. Start being a sponge. Look at the different type of programs. Make sure that you're getting updated assessments as you're approaching the age of 18, and that would be very useful. Neuropsychology exams, psychology exams, psychiatrist exams, reports are very useful when you're going to apply for disability benefits from the Social Security Administration. If you have estate planning documents, look at them, review them, make sure that they say what you want, that they're not too old. Laws change. We just had a change in the Maryland Power of Attorney Act. The changes came in effect October of 2023. There's always movement in estate planning as far as exemptions go, gift tax. It's just really important to keep an eye on your documents. We usually recommend every 3 to 5 years. If you don't have a special needs trust, or you have a very old special needs trust, it's really important to get that. If you have an old one, have that trust looked at. There's been lots of changes in the Social Security Administration manual, particularly around early termination provisions in trust, and there is a way to rectify those and bring those up to speed, so to speak. Develop a functional system to maintain records. Just like in the before 21 world, where you have IEPs, you have a lot of paperwork on the other side of transition. You have medical records that are important. You're going to have, a PCP, which is your child's plan. If you go self-directed, you're going to have budgets. There's just a lot of paperwork. figure out a succession plan for your family and for your disabled child in particular. Make sure it works. Have those hard discussions, and they are hard. It's really hard to ask somebody, can you, if something happens to me, can you come and take care of Abigail? It's really hard. But it's very important because no one has the crystal ball, right? Identifying and utilize resources. Join parent groups. You have a great association here, lots of resources. Bounce ideas off of each other. We have a very when Abby came out of the Maryland School for the Blind, we thought out of the box. She needs 24/7 care, literally, for her medical conditions, and we didn't want to go the traditional route of a agency ran group home, so we created our own home for her. She has a roommate, and we have now 2 families that have come together and are pooling our resources and being able to go out in the community together, have play dates. It's just been a really great experience for Abby, and that was just by thinking out of the box and finding other family members who are doing the same thing. So I encourage you to be resourceful and creative with your planning, and just seek support. It's a time of concern. It's a time of just being frankly scared when you go to transition from the under 21 world. But there's lots of organizations out there to help you. A lot of parents are very much willing, who've been through transition, to talk to you about their experiences as well. So here's some resources. I am a member of the Special Needs Alliance. Special Needs Alliance is a national attorney association. It is made up of individuals that do nothing but special needs planning, like me. There's NALA, which is the National Academy of Elder Law Attorneys. They have a lot of great resources as well. Maryland ABLE program for the ABLE account that I talked about. By Their Side, great advocacy here in Maryland. The Options Group is another organization that's really helpful. The Maryland Developmental Disabilities Council created Planning Now. That's a really great resource book. You can go to their website, click on it, print it out. It's very, very helpful. And then if you want to get information about guardianship, you can take a look at that at the Maryland Judiciary website. They've got a lot of information about guardianship there.